What happens when legal borders clash with human need? Across Latin America, thousands seek protection, but the legal response varies by country, by policy, and by interpretation. In this lesson, you'll explore how refugee law is applied in complex, real world contexts and build the language to explain it with clarity, precision, and authority. This is part of our full legal English course for lawyers and legal professionals. If you want access to all the lessons, plus community support and live practice, join us in our school community. The link is in the description. In today's lesson, we're diving into one of the most urgent and complex legal fields in the region, refugee law in Latin America. You'll build the language to describe how legal protections are applied or not applied across borders. You'll see how terms like asylum, complementary protection, and mixed movements are used in practice, and you'll learn how to speak about vulnerable groups and systemic legal barriers with clarity and accuracy. We'll focus on two advanced grammar tools today: the subjunctive, which is often used when talking about what should happen in legal protections but hasn't, and modal verbs to express certainty, possibility, or legal obligation in refugee determinations. By the end of this lesson, you'll be able to describe real legal scenarios in Latin America using the appropriate legal terms, nuanced grammar, and high-level vocabulary, the way human rights lawyers, asylum officers, and policy advocates do. Let's begin. Let's begin by thinking critically about today's topic, refugee law in Latin America. This isn't just about borders, it's about how the law responds to people in crisis. Different countries, for example, in the region, apply the Cartagena Declaration, the 1951 Refugee Convention, and national policies in different ways. And often, the legal definition of refugee doesn't reflect the lived reality of those fleeing violence, instability, or economic collapse. Let's complete the prompts with examples that reflect real legal complexity. One legal challenge in refugee protection is ensuring due process in mass displacement situations where resources are stretched and individual interviews may be rushed or skipped. If a person is denied refugee status, then they may be subject to deportation despite facing serious risks back home, especially if they lack access to appeal mechanisms or legal representation. Latin American countries should strengthen regional cooperation to create more harmonized procedures, especially for large-scale mixed movements involving families, unaccompanied minors, and survivors of gender-based violence. These are the kind of ideas and language we'll work with today so you can speak clearly, legally, and humanely about some of the most urgent legal issues in our region. Non-refoulement, which is actually a French word, but it's the most fundamental principle in refugee law. This principle comes from the 1951 Refugee Convention and is now part of customary international law. It means that no one can be sent back to a place where they face persecution, torture, or other serious harm, even if they haven't been formally recognized as a refugee yet. Here's a real-world scenario. A Venezuelan activist flees to Peru after receiving death threats. Authorities begin deportation proceedings, arguing that he doesn't qualify as a refugee. His lawyer appeals, invoking non-refoulement, and argues that returning him would expose him to targeted violence. The judge agrees, stating deporting the applicant would violate the principle of non-refoulement. Even without refugee status, this legal safeguard protects people at risk. In Latin America, this principle is embedded in many constitutions and migration laws, but its application can be inconsistent, especially in times of political pressure or mass arrivals. Complementary protection. Not everyone qualifies as a refugee, but that doesn't mean they're safe to return home. That's where complementary protection comes in. This legal term refers to status for people who fall outside the strict refugee definition but still face serious harm, such as torture, inhumane treatment, or other violations of fundamental rights. Here's an example of how it might play out. A Salvadoran woman flees gang-controlled territory. She doesn't have political opinions or belong to a particular social group, at least not in the convention sense. But her brother was murdered, and she's received credible threats. She fails to meet the formal refugee criteria, but her removal would put her life at serious risk. So, the Immigration Tribunal grants her complementary protection under human rights law, a status that allows her to remain legally in the host country with access to health care, documentation, and protection from deportation. This kind of protection is especially important in Latin America, where many forced migrants fall between legal categories. Mass influx. In refugee law, timing and scale matter. And when thousands cross a border within weeks, it's known as mass influx. This term describes a situation where the number of displaced people exceeds the capacity of the receiving country to process claims individually. It triggers emergency responses, sometimes legal shortcuts, and sometimes temporary protections. Consider Colombia, 2018. Within months, over 500,000 Venezuelans crossed the border. Local authorities couldn't conduct individual asylum interviews fast enough, so Colombia created a temporary permit system, allowing legal stay and access to basic services while bypassing the standard refugee procedure. In legal terms, this was a response to mass influx, a situation that justifies exceptional measures. Mass influx is common in Latin America's mixed movements. The legal challenge is finding the balance between efficient protection and safeguarding individual rights, especially in states with limited resources. Credible fear interview. Before someone can access full asylum procedures, many countries require a credible fear interview, an initial screening to see if the person has a real, well-founded fear of persecution. This is especially common at borders or detention centers. Officers ask questions about past harm, threats, political or social identity, and what might happen if the person returns home. Here's a practical example. A Nicaraguan journalist is detained at the southern Mexican border. In the interview, she explains that she received anonymous threats. Her press office was raided, and 2 colleagues have been arrested. The officer finds her testimony consistent, detailed, and connected to her profession, so she's cleared to present a full asylum application. For example, she passed the credible fear interview and was allowed to pursue her asylum claim. This step can determine everything, and it's often the first legal challenge in a refugee's journey. Due process. Even in urgent situations, legal systems must follow rules, and that's where due process comes in. This principle guarantees that individuals have a fair opportunity to present their case, access information, and challenge decisions that affect their rights. In refugee law, due process means more than access to courts. It includes interpreters, legal aid, proper notice, and appeal mechanisms. Here's an example. A Haitian man is detained in Panama. He's told he'll be deported the next day, but he doesn't speak Spanish fluently, has no lawyer, and was never informed that he could apply for asylum. His removal is challenged in court. The judge rules the asylum seeker was denied due process during removal proceedings. The deportation is halted. Due process protects the integrity of refugee systems, ensuring that the state's power doesn't override the rights of the vulnerable. Internal flight alternative. Not all asylum seekers face danger in every part of their country. In legal terms, if someone could avoid harm by relocating internally, they may be denied refugee status. This is called the internal flight alternative. But the key question is the alternative truly safe and reasonable? Consider this case. A Honduran woman flees gang violence in San Pedro Sula. She seeks asylum in Costa Rica. The immigration officer argues that she could have moved to rural south of Honduras instead, but her lawyer shows that gangs operate nationwide and that she would have no access to protection or support in the alternative location. The decision is overturned. The applicant did not have a viable internal flight alternative. This concept is very controversial and dangerous when misapplied, and it's often used to justify rejections without fully understanding the local risks, especially in countries with weak rule of law or widespread violence. A surplus claim. Not all refugees flee because of past events. Sometimes the risk of persecution develops after they've already left. This is called a surplus claim, from the French meaning on the spot. Here's a realistic scenario. A Cuban student travels to Argentina on a scholarship. While there, she joins anti-government protests and posts criticism online. Months later, her visa expires and she fears returning, not because of her past, but because of her new political activity abroad. Her lawyer helps her submit a surplus claim, arguing that her actions now place her at risk if she returns. These cases are complex. Authorities must consider whether the new risk is genuine and whether the activity was voluntary, staged, or politically motivated. But legally, surplus claims are fully valid under the 1951 Convention and many national laws, especially in Latin America, where activism is increasing. Temporary Protection Status, or TPS. When mass displacement occurs, governments don't always have time or capacity to process every refugee claim. That's where Temporary Protection Status, or TPS, becomes a practical legal tool. TPS provides short-term legal stay and access to basic rights for people fleeing serious crises without formally declaring them refugees. Here's a real-life example. In 2021, Colombia created a TPS program for Venezuelans, offering legal status to over 1.8 million people. This didn't involve individual asylum interviews. Instead, it gave them work permits, health care, and protection from deportation for 10 years. Example, Colombia granted TPS to thousands of Venezuelans under emergency regulations. TPS doesn't offer full refugee rights, but it can be life-saving. It also reflects solidarity-based legal approaches, especially in Latin America, where regional agreements often prioritize humanitarian response over strict classification. In refugee law, individual interviews are ideal, but not always feasible. When thousands flee a known crisis and the risk is obvious, authorities can grant refugee status automatically. That's called prima facie recognition. This term comes from Latin meaning at first sight, and it's used when the facts speak for themselves. A regional example of this could be Nicaragua after April 2018. After severe political violence in Nicaragua, there were countries that declared that all Nicaraguans fleeing after April 2018 would be prima facie recognized as refugees. No interview was needed. Governments relied on clear public facts about widespread repression and human rights abuse. And so, governments granted this prima facie recognition to all displaced persons arriving from the conflict zone. This approach speeds up protection and respects the urgency of mass movements. It's used in emergencies and shows how law can adapt to real-world conditions while still protecting rights. In legal English, the subjunctive mood is often used to express obligation, urgency, or hypothetical recommendations, especially in formal or professional contexts. You'll hear it in courtroom orders, legal briefs, and diplomatic documents. Let's look at a few examples. The judge ordered that the applicant be released immediately. We don't say is released. The base verb be stays unchanged. That's the subjunctive form. It shows the action is required, not merely reported. It is essential that the process respect due process guarantees. This could appear in a legal report or international monitoring review. The word essential signals the urgency, and the verb stays in the base form. We recommend that the government not deport individuals before screening. Again, not deport. Not doesn't deport or will not deport because we're expressing an urgent recommendation. In refugee law, this structure is common in UNHCR statements, national reports, and NGO advocacy documents. Mastering the subjunctive helps you sound precise, formal, and persuasive. In legal English, especially in refugee law, modals help express degrees of certainty and legal obligation. The word you choose, must, may, could, can change the strength of your argument. Let's break them down. High certainty and legal obligation. The applicant must be granted a hearing under regional law. This word must shows legal necessity. It's not optional. You'll see this in statutes and judgments. Moderate possibility or legal flexibility. The state may invoke national security to limit entry. The modal may expresses permission, but it also suggests discretion. Not every case will justify this limitation. Hypothetical risk or consequence. Deportation could violate the principle of non-refoulement. Could expresses risk without certainty. This is especially useful when warning a client or when reviewing possible legal outcomes. These modals are essential when writing submissions, advising clients, or interpreting legal frameworks in uncertain or evolving situations. Now we're going to talk about the 5 elements of the refugee definition. Let's begin with the first key element of the refugee definition. The person must be outside their country of origin. This is a fundamental condition under international law, specifically the 1951 Refugee Convention. So why is this important? It's because international refugee protection only applies when a person has left their country and is seeking safety in another state. If a person is still inside their country, no matter how dangerous the situation may be, they are not considered a refugee under the convention. That brings us to the concept of internally displaced persons, or IDPs. IDPs are people who are fleeing violence, conflict, or persecution, just like refugees. However, the key difference is that IDPs remain within the borders of their own country. They don't cross an international frontier border. Let me give you a real example. In Colombia, for many years, the country held the highest number of IDPs in the world, with more than 7.8 million people displaced due to internal armed conflict, land disputes, and organized violence. These individuals were clearly fleeing threats, but because they stayed inside Colombia, they don't qualify as refugees. The legal consequence of this is that IDPs fall under the responsibility of their own government, whereas refugees are under the protection of the international community, particularly the UNHCR, which is involved in the process, the UN's refugee agency. So, to summarize this element, a person must be outside their country to be recognized as a refugee. If they are still within national borders, they may receive humanitarian assistance, but not legal refugee status. Now we move to the second requirement for refugee status. The person must have a well-founded fear of persecution. And this is one of the most important and most complex elements in the refugee definition. It combines both emotional experience and factual analysis. Let's break it down into 2 parts. First, there's a subjective component. It's subjective. This means we ask, does the applicant personally feel afraid to return? The fear must be real for them, not imagined or hypothetical. They might express this fear by saying things like, if I go back, I'll be killed. I'm afraid of the government. I was threatened before and I know it will happen again. I don't want to go back. This is about the person's personal state of mind and their emotions, their memories, their perception of danger. But that alone is not enough. The second component is the objective component, where we ask, is there an objective reason for that fear? Is their fear reasonable based on the facts? In other words, it's not just about what the person feels, but whether that fear is justified in the broader context of what's actually happening in their country. This is where we bring in country of origin information, also known as COI. We compare the applicant's story with credible reports from sources like human rights organizations, news reports, academic research. The goal is to see if their fear matches the reality of their country. For example, if a woman from a country with high rates of gender-based violence says she fears being forced into marriage or harmed for rejecting it, and we see that those practices exist and go unpunished, that strengthens the objective part. But if someone claims persecution by the government in a country with a strong rule of law and democratic protections, that might require more evidence to support the claim. So, in summary, to meet this requirement, both parts must be present. The subjective fear that the person is truly afraid, and the objective basis that fear is grounded in reality. This dual test helps ensure that refugee protection is given to those who need it, based on a combination of personal experience and verifiable risk. Now we move to the third and most debated element, persecution. This element goes to the heart of the refugee definition, and yet there's no universally agreed upon definition of what persecution actually is. However, we do have legal guidance from the 1951 Refugee Convention, from case law, and from UNHCR's handbook and guideline. So let's break it down. What is persecution? The concept of persecution includes serious harm, not just inconvenience or hardship. We're talking about threats to life, liberty, or other fundamental human rights. Under Article 33 of the Refugee Convention, which prohibits refoulement, we can infer that persecution includes threats to life or freedom due to race, religion, nationality, membership of a particular social group, or political opinion. Examples of persecution include arbitrary arrest or detention, torture, death threats, forced sterilization, sexual or gender-based violence, total denial of education, livelihood, or religious freedom. But, and this is very important, not all forms of unfair treatment qualify as persecution. Let's look at persecution versus discrimination. This is one of the most common areas of confusion. Almost all societies have some level of inequality or differential treatment. This does not automatically amount to persecution. The key question is, does the discrimination rise to the level of serious harm? Discrimination becomes persecution when it has serious consequences: inability to work, study, access health care. It creates ongoing fear, insecurity, or exclusion. It's systematic or targeted, and especially when it is tolerated or enabled by the state. Let's look at an example. If a minority group cannot attend public school, work legally, or receive health care because of their identity, that's more than discrimination. That's persecution. If a woman is denied police protection from domestic violence because she is a woman, and the law systematically ignores this, again, this could qualify as persecution. Even if each individual act isn't extreme, a pattern of discriminatory treatment can create a cumulative effect that amounts to persecution. When the state is involved or not, persecution doesn't have to come from the government. It can also come from non-state actors like gangs, extremist groups, or even family members. But if the government is unwilling or unable to protect a person, for instance, in some countries, violence against LGBTQ plus individuals is committed by private citizens, but the state turns a blind eye. That's still persecution. In cases of domestic violence, if the authorities systematically fail to protect victims or laws don't offer real protection, that failure can be considered persecution. UNHCR guidelines even mention gender-based violence, including rape, forced marriage, female genital mutilation, trafficking, and honor-based killings. When these occur in a context of state tolerance or inaction, they rise to the level of persecution. So, in summary, not every injustice or hardship is persecution, but when harm is serious and is connected to a protected ground, which we'll discuss next, and the state fails to stop it, then it likely meets the standard for persecution under refugee law. Understanding the difference between persecution and discrimination is essential because this is often considered the most contested part of a refugee claim. Now, let's turn to the fourth element of the refugee definition. The persecution must be based on specific legal grounds. In other words, not all persecution qualifies. To be a refugee, the harm must be connected to why the person is being targeted. The 1951 Refugee Convention lists 5 protected grounds. Some countries, for example, add a 6th. In Costa Rica's case, gender is also a reason. Now, let's go through each one in detail with examples. Number 1 is race. This includes not just skin color, but also ethnic origin, descent, ancestry. The classic example is in Nazi Germany, where Jewish were persecuted and millions killed, based on the idea of racial inferiority. The Nazi ideology considered the Jewish people an inferior race and used that belief to justify genocide. Under modern international law, any act of racial discrimination that leads to serious harm or denial of rights can form the basis for a refugee claim. Religion. Now, religion is not limited to formal institutions. It includes personal belief systems, the right to practice or not practice religion, and the right to change religion. An example of this is the extremist group Boko Haram in Nigeria. They've carried out bombings, assassinations, and mass kidnappings targeting Christian communities. This is persecution based on religion. Refusing to follow religious customs or converting to another faith can also lead to persecution. Nationality. Here, we're not just talking about legal citizenship, but also ethnic identity, linguistic or cultural groups, geographic origin. For example, a person from an ethnic minority within a country, such as the Kurds in parts of the Middle East, might be persecuted not because of their passport, but because of their national identity. A common one is the Mosquito in Nicaragua, or the English speakers in Cameroon. This also includes situations where a person is stateless, meaning they belong to no recognized country, and they're targeted for that reason. Membership in a particular social group. This is one of the most flexible and most litigated grounds. A social group is typically a group of people who share a characteristic that is immutable, something they cannot or should not be required to change, or something that is so fundamental to their identity that it should be protected. Examples include families, because family ties are immutable, LGBTQ plus individuals, victims of human trafficking, former child soldiers, human rights activists, teachers, journalists, union leaders in oppressive regimes. The group must be recognizable in society, and the persecution must be linked to that membership. Also, this includes people who are perceived to belong to such a group, even if they don't actually identify that way. Political opinion, the fifth one. This is broader than being in a political party. It includes criticism of the government, activism for rights or reforms, refusal to follow political orders, opposition to armed groups or criminal networks. Importantly, it also includes cases where the person doesn't hold a political opinion, but the persecutor thinks they do. For example, a journalist who reports on corruption, a teacher accused of subversive ideas, someone believed to be connected to an opposition group, even if they're not. And another one that we talked about before is gender, which is recognized in some regional and national systems. Gender is not in the 1951 convention, but many countries and legal systems now accept it as a ground. This includes persecution because someone is a woman, especially in patriarchal or violent contexts, or because someone transgresses gender norms like members of the LGBTQ plus community. Examples of this can be domestic violence when the state fails to protect, sexual violence or rape used as a tool of control, female genital mutilation, forced marriage, violence against trans individuals, denial of education for girls. If the state tolerates or enables these harms and there's no meaningful protection, then they rise to the level of gender-based persecution. Final point, it's also critical to remember that the person doesn't need to declare their political opinion, their sexual orientation, their religion, or group membership. If the persecutor believes they belong to that group and acts upon that belief, it still qualifies. So even a perceived political opinion or identity can trigger refugee protection. So, in summary, to satisfy this element, the person must show that the persecution is not random, but rather it is targeted based on one of these protected reasons. Without that link, the claim fails, even if the harm is serious. That's why this part of the definition is so legally significant. And now we've reached the fifth and final requirement to qualify as a refugee. The person must show that their home country cannot or will not protect them. This element focuses on state protection, or more precisely, the lack of it. Let me explain what that means. Who must provide protection? Well, under international law, a person should first seek protection from their own country. Only when that protection fails does international refugee protection apply. So the central question becomes, is the government of the country willing and able to protect from persecution? Let's take scenario one. The state is the persecutor. In some cases, it's very clear that the government itself is the source of harm. An example of this is political dissidents in Nicaragua who criticized the regime, human rights defenders in Venezuela are harassed or imprisoned by the state. In these situations, it is obvious that there's no protection available because it's the government. The government is the actor causing the harm. As a result, this element is automatically satisfied. In scenario two, it's more complex. The persecutor is not the state. So, for example, the persecutor could be non-state actors, such as criminal gangs, armed groups, extremist religious factions, family members, or abusive partners. The applicant must prove that the government is unable or unwilling to control those actors. For example, in some countries in Latin America and across the world, gang violence is widespread, and those governments have often failed to prevent or punish those responsible. For example, in some countries, victims of land disputes or paramilitary threats may report crimes, but receive no real protection due to corruption and or weak institutions. In some countries, women fleeing domestic violence are denied legal remedies or ignored by law enforcement, especially in rural or patriarchal societies. So the question becomes, does the country have a functioning justice system? Is there a real chance that the police or courts would protect the person? If not, then the refugee claim can succeed on this basis. What does protection mean? Protection doesn't mean just laws on paper. It must be real, effective, and accessible. Let's say a country has laws against gender violence, but police refuse to file reports. Courts delay cases for years, victims are blamed or silenced. Then those laws are not effective protection. Also, protection must be available nationwide. You can't simply say, go live in another part of the country, unless there is a viable internal protection alternative, meaning it's safe, accessible, and sustainable. So in summary, to meet this final element, the applicant must show the state is persecuting them or the state is failing to protect them from others who are. If a government is incapable, corrupt, complicit, or simply ignores the harm, then that person has a right to seek international protection as a refugee. This element ensures that refugee law applies only when domestic protection systems have broken down and when no other safe options exist. Let's review what we accomplished in today's class. First, we built your vocabulary for complex refugee law scenarios, from non-refoulement to TPS and prima facie recognition. You can now speak about protection mechanisms with clarity and precision. Then we focused on grammar that makes your argument stronger, using the subjunctive for legal obligation and modals to express varying degrees of certainty and risk. We also broke down in detail the 5 legal elements of refugee status, step by step, with real-world stories from across Latin America. You now have the language to explain eligibility, identify gaps, and discuss legal reforms. Finally, we brought everything together through case examples and structured argumentation, preparing you to communicate like an advocate in high-stakes international protection conversations. Want more? Join our Legal English program to practice this language with expert feedback and guided simulations, and become the lawyer who can explain refugee law clearly, professionally, and with purpose.